Welcome to Truth Shoot. This is Sister Kristen, otherwise known as Misconduct. We're talking today about the bank loan. So you think the bank loaned you money. What we're talking about is we are discussing, for research purposes only, the strategy of writing a letter to your bank and asking them one question. Should the one who funded the loan be the one who gets paid back? It's kind of important. You never need to enter into a class action court case with a bank. Just file your own case. If it's already a class action, then you're going to win. It's not easy to beat the banks. If you're going to go up against the banks, you're going to need to file an individual lawsuit claiming that the bank did not perform. The bank breached the agreement and concealed material facts. And don't be afraid to file a lawsuit against the banks. The bankers fail when they cannot or will not answer the questions. This is not legal advice. These are legal strategies we're discussing. The banks got you fooled. If the banker wrote the agreement, have them explain it. If they refuse to explain it, then how can there be an agreement? You go look at your paperwork. You're going to see, first of all, you're the only one who signed it. Furthermore, they like to use this opening statement that goes something like this. It says, "For a loan I already received." Now, that's a problem because when you sat down to sign that promissory note, you had not received the loan yet, so-called. That's what you were sitting down to sign the paperwork for. So they have you sign something that says, "For a loan I have already received." The banker and the judge will try to get you to agree. Is that your signature on the agreement? So that means the bank lent you money, and therefore you must repay the money. If the judge says, "Is that your signature?" Some people say, "No, it looks like a forgery. I do not understand what this document is. Can you stipulate if this promissory note acts like money or the equivalent of money used to fund a bank check? Can you stipulate all the material facts about the promissory note or what the agreement is so that I can understand what it is that my alleged signature is validating? I do not understand if the agreement says that I'm supposed to provide the capital or if the banker is going to provide the capital to fund the loan. If I don't know what is agreed upon in the document, then how can I testify that my signature is on it? When the judge demands a yes or no answer, some people say that they will answer when they explain what the agreement is. How can you testify to something that you do not understand and that they refuse to explain? If you agree that it is your signature, you lose the case. Your signature is proof that you agree that the bank lent you their money and that you owe them your money. The judge may demand that you say that the bank lent you money that resulted in your purchase of a house or a car. But if you agree that the bank lent their money to purchase your promissory note, then you are testifying that the bank violated the law, the GAAP, which is the general accounting principles that every bank must comply with if they want to continue to do business. You funded your own loan with the promissory note, basically. In reality, per GAAP and the Federal Reserve publications, 2 loans were exchanged. You gave the promissory note to the bank that funded the loan back to you. If the loan from you to the bank is the deposit of the promissory note, Under GAAP, then the bank is required to match a new bank liability with your name on it, showing that the bank owes you for the deposit they accepted from you, just like they do when you deposit cash into your checking account. The banker knows, as well as the judge, that when you deposit cash into your checking account, you lent the bank your money. If you withdraw your money, the bank lent you nothing. The form, the contract, says that the bank lent you money, but the substance, the bookkeeping entries, say that the bank accepted your promissory note as new money as a deposit. It doesn't get created from the sky like what they say. They say, oh, they're creating money out of thin air. No, they're not. You created the money with your signature on the promissory note. The bank accepted money from you. The bank never gave up one dime of the bank's money. The bank accepted money from you and deposited it, which is the exact opposite of lending you money. If you lent the bank money and they returned the same money to you, then two loans were exchanged. Now, the bank's charter requires the bank to follow the law, the GAAP, or the contract is an illegal contract, since the contract said interest, which is defined as a charge for the use of borrowed money. So, we can presume then that the party who funded the loan is to be repaid the money, right? The bank claims that the bank funded the loan and should be repaid the money, but the bookkeeping entries prove the opposite. Did the agreement say that the bank was to steal the promissory note, alter it to become money, and then return the stolen money as a loan? Or did the bank use their money to purchase the promissory note from you without the economics similar to stealing, counterfeiting, and swindling? Lack of consideration is a personal defense. They cannot explain if they followed the GAAP, nor if the intent of the agreement is that the party who funded the loan should be the one who gets paid back, per GAAP and the bookkeeping entries. The bank merely acted as a money changer, and they should get a fee for that. But they're charging you as if there was a loan. Two loans were exchanged. You must repay the loan, and the bank never has to repay its loan from you to the bank. They concealed the loan from you to the bank, creating the economics similar to stealing, counterfeiting, and swindling. An agreement means mutual understanding and no concealment. No title passes in a theft per the Uniform Commercial Code. Federal banking law knows that GAAP was violated. You can use a CPA expert witness to confirm GAAP. The banks cannot put up an expert CPA witness and answer our questions. Then place the questions in the request for admissions, admit or deny, which they are not likely to answer. They never answer. Okay, they can't. They'll get in trouble either way if they answer. If you ask them if they use the GAAP accounting method, which yes, of course they do. They are required to, or they cannot continue to do business, and they want to continue to do business. This loan with you is not going to hang them up one bit. So, you put the questions in the request for admissions to admit or deny, which they're not likely to answer, which might allow you to go and get a summary judgment without the need for a trial at all. You had better really know law and courtroom procedures, or you can expect to lose unless they do not answer the lawsuit. Even if they do not answer the questions or answer the lawsuit, do not expect the bank to let you off the hook that easily. Do not stop making payments or they will foreclose. Some people send a new promissory note in the amount of the original note, payable in the same species of money or credit that the bank used to fund the loan per GAAP, thus ending all interest and liens. Then they write loan payment checks payable to the new note if they wish to continue to still do so. Now, if the bank accepts the checks, then you have a new arrangement. If they do not, you might claim breach of agreement since you tried to learn the facts of the agreement and they refused to explain it to you. That means it's not binding on you then. Okay? We write notices to learn what is the real agreement. When they refuse to tell us, we look at it as a breach of agreement, concealment. People try to stay away from the word fraud. It's a dirty word. If you say fraud, you have a greater burden of proof. You should instead say it is a breach of the contract, it is a breach of agreement. And no one is allowed to breach or break contracts. That's the law. The law is the contracts, contracts, contracts. They stole the note, and you want it returned. Or for them to fund the loan. They have not performed to their end of the contract. When the stolen property funded the loan, that was a breach of the agreement. Guess what? The promissory note had cash value, face value. They never tell you who owns the note. They sell the note on the day it gets signed. Now, let's say you pay it off, and then 5 years later, the real owner of the note forecloses. Sometimes they don't even have to give you any paperwork. They'll just go and publicize it in the newspaper, and they'll tell you, oh, that's all we had to do. And take the house right out from under you. Why? It's simple. You never got the original note back, so you cannot prove that you paid the note. People have been foreclosed on who have paid the note 5 years or more in the past, but they lost the one piece of paper saying it was paid off. That's why it is important to see the original note and get it back. And don't burn it. That's a dumb thing to do. Like I said, it has cash value, so you should turn it over, endorse it, and cash it in. That's why it's so important for you to make sure that the one who funded the loan is the one who's getting paid back. So you don't have any surprises later on. And you have a right to know that. You need to know that. This is not legal advice. These are legal strategies. But the same knowledge applies to credit cards. You can send an invoice to the credit card company, then send an opportunity to cure and pay the invoice. Then send a default judgment. Now you can sue the credit card company in small claims court. And this is how you win before you ever go to court. Results have been that the credit card companies have issued checks to borrowers in small claims court. Most courts will not allow you to sue an out-of-state business. Check the agreement regarding jurisdiction, arbitration, and court location. There are a series of cases, court cases, on void and voidable judgments. The attorney foreclosing did not tell you that he is a debt collector, per the Supreme Court ruling. You had no opportunity to demand verification, such as an affidavit signed by the attorney with personal knowledge verifying the debt. The attorney forces you into court and wins. The attorney broke the law by not informing you that he is a debt collector. People have won court cases showing that the first court case is void and reversed the judgment. Because if a judgment is void, then it must be set aside. They have no choice. And there is no statute of limitations on a void judgment. So if you can show the court that the judgment is void, and there are 5 things that you can do to show that, then it must be set aside. The Chicago Federal Reserve Bank publication, Modern Money Mechanics, on page 6, says that the bank records the promissory note as a new bank liability, commonly called a checking account. If anyone wants to book a phone consultation with me, they can. It's an introductory rate of $25. And then hit me up at my email address with your phone number. I will contact you. Anyone who's suffering behind a mortgage should contact me for strategies to keep your house. So they acted as a money changer and told you they gave you a loan. Now, what does it matter, Kristen? What does it matter where they got the money? Well, it matters to me. Just remember, brothers and sisters, if you want judgment, bring it. You have to learn how to enforce everything in this life. Take care. I'll see you in the next video.